Good afternoon. This webinar offers closed captioning. To enable closed captioning, click on the live transcript button on the bottom of your screen and choose your preferred method. Welcome to the City of Chicago Department of Business Affairs and Consumer Protection webinar. Please note any website or email that I mention will be posted in the chat box. For those seeking business licensing assistance, you can visit the Small Business Center at City Hall or call 312-74-GO-BIZ. Also, business licenses can be applied for or renewed online at chicagobusinessdirect.org. If you are part of the BACP Entrepreneur Certificate Program, you can get credit for joining this webinar by sending an email to bacpoutreach@cityofchicago.org. If you want to learn about the program, please visit chicago.gov/businesseducation. Also, this webinar is being recorded and will be available at youtube.com/ChicagoBACP. I will post the mentioned information in the chat box. We encourage attendees to ask questions. Please use the chat box to send your questions. There will be a Q&A session at the end of the presentation. Please note that the views, information, and opinions expressed during the webinar are solely those of the presenter and do not necessarily represent the official policy or position of the Department of Business Affairs and Consumer Protection or the City of Chicago. Today's webinar will be Entity Selection and Formation, presented by the Donald Pritzker Entrepreneurship Law Center, Northwestern Pritzker School of Law. Esther and Darren?
Hi, everyone, and thank you so much for the introduction, and thank you so much for inviting us to be with you today. Thank you all for being here with us. I'll quickly introduce myself and pass it over to Darren, and then we will get started. I'm Esther Barron. I'm part of the Donald Pritzker Entrepreneurship Law Center. I teach a lot of classes focused on innovation and entrepreneurship. And we also have a clinic at the law school where we get to work with startup businesses and entrepreneurs and social entrepreneurs and do things like this, like workshops and office hours. So we're really grateful to be here. And we want this to be as valuable to you as possible. This is for you. So if we are going too slow or going too fast, or you have questions on something we didn't mention, please put it in the chat. Let us know. We really want to make this as beneficial as we can. And with that, I will pass it over to Darren.
I'll be brief. I'm very similar to Esther. I'm also at the Donald Pritzker Entrepreneurship Law Center at Northwestern Pritzker School of Law, teaching classes around contracts and entrepreneurship and venture capital. And just to reiterate what Esther suggested, if you've got questions, even as we're going, feel free to throw them in a chat and either we'll get to them in real time or we'll certainly save some time at the end to go over all your questions. That's fun for us to interact. So please feel free to do it. And with that, I'm going to turn it back over to Esther to kick things off.
Terrific. Thank you. So we're going to be talking about entity selection today. And I want to start with what happens if you don't set up an entity. So if you're running a business right now and you haven't made a formal selection and filed the requisite paperwork, but you're running a business on your own, you're by default what we call a sole proprietor, and you're running a sole proprietorship. If you're running a business with somebody else or more than one person and you haven't made any selections or filed any paperwork, again, by default, you actually are doing something. You're a general partnership. So in Illinois and in other states, when two or more people come together to run a business for profit, by default, you're operating what we call a general partnership. And so what we don't like, well, I'll start with what we do like. I'll be positive. What we do like about sole proprietorships and general partnerships is that they're really easy, right? You don't have to do anything. As soon as you start running your business, you automatically have that creation. But now I'll be negative. What I don't like, what Darren and I don't like, and what most lawyers don't like, is that there's unlimited personal liability. So that means any liability created by the business is your own personal liability as the owner of the business. And that's problematic, right? That puts your personal bank accounts, any assets you have, not necessarily that you put into the business, but separate from the business, just stuff that you have and that you own is at risk by virtue of running a sole proprietorship or a general partnership. And I'm going to add to that we like general partnerships even less than sole proprietorships. We don't like either one because of the unlimited personal liability. But with general partnerships, it's even more problematic because you're liable for what your partner does. So if your partner orders inventory or even gets into a car accident potentially and injures someone on their way to a business meeting, these are things that maybe you can't control. You didn't even know they ordered the inventory, and yet you could be liable for any damages or obligations that come out of your partner's actions as well as your own. So it's obligations of the business, the partnership. And you're jointly and severally liable. So someone could come after you for 100% of the loss, and then you'd have to go, fight it out with your partner to get reimbursed or indemnified. So that's a little bit about why we don't think those are good options. I'm going to share a quick story with you of how this can come up accidentally. This happened to me quite a few years ago, probably about 10 years ago at this point. A former colleague of mine called me and described this story, and this is how it goes. She said, I have a cousin who moved out west. He's really smart. He has his MBA. He works for a big consulting firm. And he moved to a city where he didn't really know anyone. And he joined a gym and he started working out with this person who's a former athlete and kind of a pseudo celebrity in that city or that town. And he started telling people at work, oh, this is so cool. I'm working out with this person that you probably have heard of and think is, that you look up to. Well, he's my trainer. People thought they were jealous. And so my former colleague's cousin said to his trainer / former athlete / pseudo celebrity said, you know what, I could get you a lot of clients. Everyone thinks it's really cool that I'm working out with you. I could, introduce you to a lot of my colleagues at work at this consulting firm. And the athlete trainer said that would be great. I'd love it. I'd love the extra money. And so they started doing this, and he referred a lot of business to this person, and they shared a little bit of the profits. I think the trainer kept most of the money, but he gave my former colleague's friend a small percentage. So he was making money too. They even set up a website where there was some information about if you wanted to work out with this trainer. Time goes on. The trainer says, you know what, I don't even have any more time to take on any more of your friends or colleagues as clients. You've totally filled my schedule. And this person says, oh, that's too bad, because I think there's still more people that would want to work out with you. Being the smart, creative person that he was, he said, well, why don't we get other trainers to use your training routine? And then people can still brag they're sort of working out with you because they're working out with a different trainer, but using your routine. And I think people would still think that was great. He was right. They got more people, and they were both doing, this was good extra money for my former colleague's cousin. Things were going well. He has a full-time job at a consulting firm. He's got a great trainer, and he's getting extra money from this relationship with the athlete. All is great until one day they meet for coffee over the weekend, and the athlete says, I know you think you're the business person and I'm not, but I have a surprise for you. I have great business ideas too. You're going to be so excited. Here's the surprise. I have rented out a whole new gym. I've ordered gym equipment. I've taken out a bank loan, and we're in business together. And to his surprise, to the athlete's surprise, my former colleague's cousin was not excited. He did not share that enthusiasm. He was horrified and was worried that he had potentially incurred some liability. So my former colleague called me and said, this is where I come in. And she said, Esther, I don't think that my cousin has any liability. But then she repeated that whole story to me and said, can you just confirm he's fine? He didn't even know that this person did all these things, but there's like hundreds of thousands of dollars at stake. I just want to let him know he has nothing to worry about. And I figured I would just run this by you so you could confirm that he's like A-okay. And I said, well, unfortunately, it's the exact opposite of that. I think there's a good argument that they formed a general partnership and that your cousin could be on the hook for half of that liability. And actually, any of those third parties could come after him for the 100%, and he'd have to go after the athlete for 50% reimbursement. I don't want anyone to worry about this person. It all worked out okay. They settled. He lost, probably thousands of dollars, but he was able to get out of the situation. So it was, a lesson learned, but there's a good chance that what he did was created a general partnership by accident, by default, without choosing to. And again, what we don't like about that is the risk of the unlimited personal liability. By selecting an entity, and Darren's going to talk about some of the choices, some of the very common choices are corporations and limited liability companies, and then there's some options if you're really more of a social entrepreneur. But by setting up and going through the formal steps of selecting and creating an entity, you basically shield yourself. You as the owner are shielded from the liability that's created by the business. So the money that you put into the business can be at risk, but your own personal bank accounts and assets are not at risk. And so that's why, we really encourage thinking about setting up an entity early, because timing is important. When I had this conversation with my former colleague, she's smart and she said, okay, I get it. I understand limited liability. Let's set up an LLC right now. Let's do it today. And I said, well, that's great. We could, but that only covers liability going forward. You can't fix what's already happened. So timing is important. So what we usually tell our clients is once you start doing something where you think you could be creating potential liability, you're signing contracts, you're selling products, you're offering your services, you're hiring, you're taking on investments, all of these things. That's the time to really think about when you want to structure and set up your entity. So again, we want to minimize liability and get rid of this personal liability. And we want to think about timing because the risks of not doing it early can create unintended liability for you individually. And so I hope I haven't scared you, but I have encouraged you to think about how important this is. And with that, I will pass it on to Darren, who's going to then talk about some of the great options you have for eliminating this personal liability.
Thank you, Esther. So I think you should all be convinced after hearing Esther talk that forming an entity earlier rather than later is generally a good idea if you're going into business to avoid that horrible state of affairs she described. So let's talk a little bit about that entity formation process. There's sort of a couple of things that we would think about when we are considering forming an entity. The first is very basic. A lot of folks put off the decision, sort of kind of say, I'm going to kick the can down the road because forming an entity must be complicated. I don't want to deal with all of the expense and the headache of it. And the good news is the actual formation of an entity is quite simple. You can form in any state, and every state makes available the forms that you need to file on their website, somewhere on their Secretary of State website generally. And for example, if you were forming an entity in Illinois, for a corporation, it would be articles of incorporation. For a limited liability company, and we'll talk about those entity choices in a moment, it's called an articles of organization rather than incorporation. The name doesn't matter. It's usually a 1 or a 2-page form. You give very basic information. You submit the form to the Secretary of State. You can generally do it online these days. Illinois has a very easy to use submission process. And it's usually around $150. It depends on the type of entity, and there's a few other things that might affect the fee, but right around there. And that's it. When you submit it, you get a stamped copy back from the state. And once you get that stamped copy, you're an entity, right? You've taken care of that initial issue that Esther was talking about, that liability issue. Now, if you have multiple owners, kind of co-founders as they're called, there are other documents or agreements that you might draft and sign between each other or among each other if there's more than two, which are a little more complicated, but those don't have to be filed with the state. Those can be done on your own time and you can sort of figure those out. The actual entity formation is fairly easy. Simple filing and then the fee to the Secretary of State. I also mentioned Illinois and mentioned other states. Once you decide you're going to form an entity, one of the first decisions you have to make is in which state are you going to form? You can form in any of the 50 states. Every state has its own body of law, corporate law, limited liability company law, and there's a set of rules in every state about how you form in that state, usually just like I described, filing a form with the Secretary of State. There's no right or wrong answer to which state you should choose, but there's some things you would think about. If you're based in Illinois and your business is going to be based in Illinois, there's a reasonable chance that Illinois is a perfectly good choice for you in which to form. Illinois has a very sophisticated body of law, and as I mentioned, an easy process to form the entity. So there's probably not much reason for you to start looking at other states. If your business was going to be based in a different state, or you were going to be hiring a bunch of people in a different state and like maybe the headquarters were going to be there, you might think about that other state, but Illinois is most likely if you're here and your business is going to be here. I'll mention one other state because you may hear of it out there. Oddly, the state of Delaware, which is not a big state, but it's a very big state as it relates to forming entities. You'll often hear of Delaware corporations or Delaware LLCs. I won't go too deeply into it. The reason that we see that is Delaware has a very sort of friendly body of law that's been around for a long time. And if you were going to raise a bunch of money, like millions of dollars, which most businesses don't, but if you were going to, sometimes like investors feel more comfortable if you're formed in Delaware because they know the law there and they like the way it reads. So I'll mention Delaware just because it's sort of floating out there. But most often, if you're in Illinois, Illinois is going to be the choice. So those are sort of the easier questions. Now we get to the one that tends to be the most challenging. And that's what type of entity should you be? There's lots and lots of choices these days, sort of more than ever. So I'm going to cover some of the principal choices, the greatest hits of sorts. And then Esther is going to cover a few sort of unique entities, some of which are sort of newer in form, depending on what type of business you're going to be launching. So I'm going to start with a basic corporation. You've probably all heard of corporations. Corporations have been around in the United States for a long time. It's one of the oldest forms of entity. It goes way back. So what are the benefits of forming a corporation? Well, there's a number of them. One is what Esther was talking about. Corporations are very good at providing that shield of liability around you, the founders. So once you form a corporation, and if you sort of do it properly, if there's trouble, and there often is trouble, unfortunately, in a growing business, it can't be avoided, and somebody decides they want to sue, they should be able to only sue that corporation, and they shouldn't be able to reach you personally as a founder, as a shareholder in that corporation. So that shield of liability is kind of thing one. As soon as you form that corporation, you sign all contracts on behalf of that corporation as an entity rather than as an individual, you should get the benefit of liability protection. Basic corporations, when you form them, when you file for a sort of a traditional plain corporation, they're often referred to as what we call C corporations. You don't really need to know the name C corporation, but that's sort of the default when you form a corporation, the basic corporation. And if that's what you are, if you're a basic C corporation, you also have lots of flexibility. You can have any number of shareholders. Your shareholders can reside in the United States or in other countries. You can issue different types of stock, like common stock, which is typically what you issue to yourselves, the founders at the beginning. If you ever took in investors, they like to get stock, which is a little better than common stock. So you can issue preferred stock. That's what we typically call the type of stock an investor would get. You can do all of these things. You can have any type of shareholder. It can be a person owning stock in your corporation, or it can be another entity, another corporation, another limited liability company. So lots of flexibility. So that's all good. You might wonder, why not just form a C corporation? It sounds like it gives me liability protection and it's flexible. And that's all true. There are some issues on the tax side, and we tend to stay away from taxes being in the legal profession because we're scared of them. But we do have to know a little bit about taxes because they're relevant, unfortunately. You may have heard the term double taxation before. At a very, very general level, what double taxation means is when a corporation, a C corporation, earns money, the IRS and the state in which it's operating treat it like a person. It's a fictional person. And just like you have to pay taxes on money you earn, so does a C corporation. It writes a check based on its profits to pay taxes at the federal level and at the state level. So that's one layer of taxation, and that's perfectly fine. But let's say your corporation's doing pretty well and you've got some money on hand, that you want to return some of that money or give some of that money to your shareholders. That's called a dividend. You probably heard the term dividend before. You can declare a dividend, which is sort of just giving some of your profits back to the shareholders. If you do that, you'll be taxed a second time. You being the shareholders will be taxed on that dividend that they're receiving from the corporation. So the corporation, if you think about $1 on a journey into a corporation, taxed one time, and then if that dollar then moves from the corporation to the shareholders as a dividend, taxed a second time. So that's what's called double taxation. We don't like double taxation. We'd rather be taxed once rather than twice if we can avoid it. Bear in mind, not all corporations declare dividends, so double taxation doesn't always come into play, but it might come into play. So how do we deal with that? Well, there's another type of corporation. I mentioned the plain corporation, the C corporation, which is the default when you file. But let's say you don't want that bad tax treatment. You can form your C corporation, and then in a subsequent filing, a second filing that you would make with the IRS, you can make what's called an S election. That S election is a little bit more complicated of a form than your articles of incorporation. But by doing that, you go from being a C corporation to an S corporation. S corporations, taking a step back, enjoy all the same liability protection that we talked about with a C corporation. So you're building that shield that Esther talked about around you and your co-founders, if you have co-founders. So that's a good thing when we think about S corporations. S corporations also do away with the double taxation problem we just talked about. They're what's called flow-through entities, single taxation entities. The IRS, they're also called disregarded entities. There's lots of names for an S corporation. But what all of that basically means is the IRS ignores them. They pretend the S corporation doesn't exist. So when the S corporation earns money, it doesn't have to pay tax to the IRS. Those profits are they flow through the entity to the shareholders, and only the shareholders have to pay tax one time, rather than the corporation paying tax and then the shareholders paying tax on the dividends. So it's single taxation in an S corporation rather than double taxation in a C corporation. So that's great. We've got the liability protection. We've got one level of taxation rather than two, more tax efficient in an S corporation. That's good. So you might be wondering again, why isn't this automatically the winner? S corporations sound pretty good. Unfortunately, there's a few issues with S corporations which have made them somewhat less popular these days. Namely, there's lots of rules within an S corporation. Rules around the shares and the types of shareholders you can have. For example, you can't have more than 100 shareholders in an S corporation. Now, for most growth, early stage businesses, startup businesses, entrepreneurial businesses, you're usually not going to get to 100 shares. That's a lot of shareholders. So maybe that one's not an issue for you, but there's other rules. You can't have entities as shareholders for the most part. You can only have individuals owning shares. So let's say you wanted to raise money, early stage money to grow your business. Sometimes investors like to invest out of an entity. They've got their own LLC or their own corporation that they use to make investments. There's a good chance that that entity wouldn't be permissible. You wouldn't be able to take money from that entity. So that's not ideal from an S corporation perspective. There's yet other issues. You can't have shareholders if they're not US nationals. If you've got somebody who's a resident of a different country, they're not allowed to hold shares in an S corporation. So that may or may not be an issue for you. And yet one more issue. In an S corporation, we talked about different classes of stock that a corporation might issue in a C corporation, the basic corporation, common and preferred stock. You can't issue preferred stock in an S corporation. You're allowed one class of stock, and that class will almost inevitably be the initial common stock that you issue to yourselves as founders to own the corporation. So if you're going to raise money, whether it was from an entity or an individual, and they say, I don't want that common stock that you got as a founder, I'm giving you money, I want something a little better in return for my cash, you can't issue them preferred stock. So S corporations can be tricky. Complying with all of those rules can be tricky. So for you all, if any of those rules might create an issue, then an S corporation may not be a great choice. But all is not lost, fortunately. Just like Esther wanted to be positive, I'm going to finish with something positive as well. There's another option out there that addresses most of the issues we just talked about. And that's called the limited liability company, or LLC for short. I'm guessing many of you have heard of LLCs. They've become a very popular choice for early stage startup businesses in recent years. The LLC was invented 40 or 50 years ago, and the idea was that they were going to take the best of corporations, regular C corporations, and the best of an S corporation, or a partnership, which actually is sort of similar to an S corporation. We're not going to talk much about partnerships, limited partnerships. Esther talked about general partnerships, which are generally a no-no. There's also limited partnerships, which are not used very often. So we're not going to spend much time talking about them. But we took the best of a C corporation and the best of an S corporation and mixed them together, and we got an LLC. So what does that mean? LLCs, you form them just like corporations, that same simple filing with the Secretary of State in the state where you choose to form. They give you that liability protection. So you get the same shield around yourselves to protect your own personal assets that you get when you form either a C or an S corporation. You have flexibility. So you can have any number of they're not called shareholders. In an LLC, they're called members. The name doesn't matter. Member just means an owner of an LLC, just like shareholder means an owner of a corporation. So they're called members in an LLC. So any number of members or owners, you can issue different classes of equity, preferred or common. They're called units rather than stock, but again, it doesn't matter. You can have folks living outside the country, folks in the United States. You can have entities or individuals as owners. So all of those frustrating rules that we saw with S corporations, we don't have with limited liability companies. So we've got the liability protection. We get rid of all the S corporation rules around ownership and numbers. And best of all, we have the single layer of taxation. So whereas C corporations, we have that double taxation problem. In an LLC, they're viewed much like S corporations. They're disregarded by the IRS, and there's only one tax paid. It flows right through the entity as the entity is ignored, rather than two taxes paid. So the LLC is kind of the best of both worlds. For lots and lots of startup businesses, the LLC is a perfectly reasonable choice for the reasons we talked about: the flexibility, the liability protection, and that's why we see lots of LLCs. There's a couple things I'll mention with LLCs that it's important to just be aware of. If you're going to be an LLC, it's a good idea to have an accountant or somebody you can get tax advice from, only because the taxes can get a little bit complicated each year. When you have an LLC, and this is similar to an S corporation, those single taxation entities, there's a document that you may have heard of, you may not have heard of, called a K-1. And a K-1 is something that often an accountant will create at the end of each year. And it sort of shows the profits and losses of your LLC and how those profits are allocated so we can figure out who owes what taxes. The details of the K-1 aren't important. What's important is just to know that you need to have one of them at the end of each year. There's some accounting that needs to be done from a tax perspective each year with an LLC. If you're good with taxes, or you work with something like TurboTax and you're sort of good with it and you're comfortable, you may be able to handle the taxes for your LLC, but lots of founders, that's not their specialty. And so if you're going to work with an LLC, you might want to have an accountant that's just used to working with LLCs to make sure that your bookkeeping is correct and your tax returns are accurate each year. The other thing I'll mention, and again, this isn't important for most entrepreneurial ventures. I mentioned at the very beginning of my talk, if you were going to raise lots of money, like millions of dollars of venture capital investment, there's certain things that those investors might expect from the company that they're going to invest in. One of the things they might expect when you get to that type of investment is they might expect that you become a Delaware C corporation. They don't like that single layer of taxation, oddly. And the reasons are a little, I won't go into all those details, but a lot of those investors are set up in ways that they can't invest into LLCs. It would mess things up with their structure. So if you were that type of business that was going to raise big dollars from a venture capital fund, sometimes you just default to a Delaware C corporation. I mentioned Delaware before, so you don't get all the tax benefits, the tax efficiency, but you're sort of the right structure to raise those big dollars. Most early stage businesses or startup businesses, even if they think they're going to raise those big dollars, it's not easy to do that. And most businesses don't do that. Most businesses, when they're raising money, raise money from friends and family, folks that you know in your network. Those types of folks can generally invest in a limited liability companies just fine. The other thing to note is, let's say you started out as a limited liability company for the reasons we just talked about, and it turns out you needed to become a different type of entity. You grew faster than you thought you were going to grow, and you're going to raise lots and lots of money, and you need to become a Delaware C corporation. These days, it's pretty easy to move from being an LLC to a corporation. There's something called a statutory conversion. It's another filing with the Secretary of State, which allows you to sort of snap your fingers and say, I don't want to be an LLC anymore. Now I want to be a C corporation. So if you ever needed to change structures, going in that direction from LLC to C corporation, you can do it fairly easily these days. So you can start as an LLC and maybe stay an LLC for the entire life of your business. But should you ever need to pivot and go a different direction with your entity, you can. You also can convert from being a C corporation to an LLC, but that's more challenging. Sometimes there's adverse tax consequences and potentially other issues you may run into. It's a little harder to go from being a corporation to an LLC than it is from being an LLC to a corporation. So, again, there's no right choice. It really depends on your business. Do you think you're going to raise a bunch of money? How many co-founders do you have? If it's just you running your company and you're never going to issue stock to co-founders or raise money, an S corporation might work for you. If you need flexibility, you're going to have co-founders. You might raise a little bit of capital. You want that flexibility. Maybe an LLC is the right choice for you. Just knowing the right questions to ask is sort of half the battle. You can sort of do additional research from there on out to figure out what works for you. With that, I'm going to turn it back over to Esther to talk about some specialized entities, sort of forms of the entities I talked about for certain types of businesses.
And then I promise we're going to get to I see that we have a few questions in the chat, and we will get to those questions as soon as I wrap up this last part. And what I'm going to talk about is, more and more entrepreneurs tell us, our clients, that they're social entrepreneurs, or that they want to have a positive impact on the world and have a social enterprise. And traditionally, when we heard that from clients, it was that they wanted to start a not-for-profit corporation and do something charitable. And that is certainly an option. We still have clients who set up not-for-profit corporations and apply to the IRS for tax-exempt status or become a 501c3. These are, vocab that sometimes people use interchangeably. But what that means is your donors, instead of investors, give you money, right? They donate money, and sometimes you can get money from foundations. And if it's from individual donors, they can get a tax write-off for the amount they donate. You don't pay federal income tax. Sometimes you don't even pay state income tax. So there's some real advantages to setting up as a not-for-profit corporation, depending on where your money's coming from. But a big difference is you don't own a not-for-profit corporation if you start it. The public owns it. They don't have shareholders or members. This is owned by the public. You can have a salary. as long as it's reasonable, but you're really starting this organization not to make a profit, not to sell in the future, not to have an exit strategy, but because you have some sort of a charitable mission, or a mission that would be considered acceptable to the IRS to get 501c3 status. More recently, Darren was mentioning, these are newer options. We have what some people sort of consider hybrid entities, where you can actually set up an entity where you want to make money, you want to own the entity, but it's also really important to you that your mission, whatever mission it is, to improve the world, is part of the structure of the entity. And sometimes it's because it's so important to the entrepreneur. Sometimes they want to message their social impact or social intent to potential customers, to employees, to investors. There's lots of reasons why entrepreneurs may choose this route. But you have to have a reason. Like, it has to be very important because there's some obligations that come with it. You actually have to make decisions. You have to weigh in when you're making decisions and consider the impact on your stated social mission. And you have to show that you're actually furthering that mission. So it really can't just be for a marketing, stand. You have to actually be doing it. And if that's your goal, then there's some options. So you can set up an L3C, which is a low profit limited liability company. Those haven't been as popular recently. What I see more of with my clients is either setting up a public benefit corporation. And so that's an actual structure like a corporation or an LLC. You can set up a public benefit corporation. Keep in mind, that's not available in every state. It is available in Illinois. But again, you have reporting requirements, and you have to show that you're actually taking your social mission into account when you make decisions, sometimes at the expense of profits. So you can't just be maximizing profits like you would for shareholders in a straight C corporation. Here, you also have to be furthering your social mission, and there's accountability and reporting to show that you're actually doing that in a serious and meaningful way. There's also something called a B Corp, where you can, and this is really a certification. It's not setting up an entity in a specific form, like the public benefit corporation. It's an entity that elects to get a certification from a not-for-profit called B Labs. And they look at a lot of the same things. They look at what the social mission is, how you're going to further that social mission, their reporting requirements. But you can be an LLC or a corporation and apply to get this certification from B Labs. One caveat to that, if you are in a state where the public benefit corporation is available, there are some requirements to either be a public benefit corporation or can convert in a certain period of time if you are granted this B Corp status from B Labs. So in any event, that's just a little bit on how social entrepreneurs have navigated these waters. That is not to say that you can't have a social mission with a traditional corporation or an LLC. A traditional corporation or LLC can still have, a mission to do something that's good for the world, as long as it doesn't minimize or reduce profits to shareholders. Or you can, there are some rules about giving some money to charitable causes, and there's lots of companies that have made the argument that doing something that's good for the environment or for the world or some social mission actually increases sales and is good. Customers like that. So there's ways to say that is actually still consistent with a true for-profit corporation or LLC. But we now have these newer models where the social mission is so integral to the business and to the founder's vision that they want to bake it into the actual structure or to a certification for the business. And so with that, we don't have a ton of time left, but we definitely have time to go to questions, and we have some in chat. And so Darren and I will start going through the chat and answering your questions. So Darren, if you want to take the first one.
Sure. In no particular order, is there a specific form to change from one structure to another? So this is what we were talking about before. If you start as an LLC, and you decide, I need to be a C corporation for some reason. And the answer is yes. There's the form is called something different in each state, but that same place where you get your articles of organization or articles of incorporation when you formed your entity, somewhere else, usually on that same page, there'll be something about converting an entity. It can be called different things in different states, but it's generally called a statutory conversion. And there is a form, and that form might be a statement of conversion or plan, something like that. Okay, we call different things. So you just download that form. That's usually a form you wouldn't file online. Usually you would download it, fill it out, and you'd submit it to the Secretary of State. Of course, they'll want a little fee. They always like a little fee when you submit something. But yes, there is a form to do that. And once you're done, your entity is now that new type of entity. And the nice thing about it is it's considered the same entity. You don't have to like assign all your contracts or get a new EIN. Those of you that have entities have probably gotten employer identification numbers with the IRS. When you do a statutory conversion, you keep the same EIN. So it's sort of easy. So yeah, there's a form, you can file it and change forms.
Fabulous. And I'm going to take two questions because they're both related to not-for-profits. Can you have two businesses, one a for-profit and one a nonprofit? So the easy answer is absolutely. You can have two different businesses. Now it gets trickier if you try to connect those businesses. And you can't have a not-for-profit or a tax-exempt organization that's really for the benefit of a private individual or a private company. So as long as they are totally separate, you're fine. But if you start mixing them, you can get into trouble. And I'll give you a really quick example of what you can't do. So imagine you're a not-for-profit that gives kids opportunities to have like tours of really interesting places around Chicago. That's great. That's what your not-for-profit does. It takes, gives kids free tours of interesting places in Chicago. That's probably an acceptable mission, a charitable mission, educational, terrific. Now, if you have a for-profit business that gives tours to people and you start, getting grants for your not-for-profit business to provide opportunities to kids, and then your for-profit business takes it, gets the advantage of the scholarship where they get the money from the not-for-profit to provide a free experience to the kid, that's not okay. So then you're crossing lines. So hopefully that gives you at a very high level, yes, you can have two totally separate entities, but when they start having any kind of connection, you have to be careful because there are a lot of rules surrounding that. And then there was another question on not-for-profits, but how do you know if a salary is reasonable? It's tough. So there's no sort of magic answer to that or scientific answer. But what I usually advise clients is look at what similar organizations, so similar size, similar geographic location, maybe similar role of the person that you're comparing, what are they paying? And then you can make an argument that that's reasonable. So if you're at, you start a not-for-profit in Chicago and has $100,000 budget and 3 employees, and it's for a particular role, like maybe the IT person, look at some similarly situated organizations in the Chicagoland area around the same size budget, around the same size staff, similar role, and then get a sense of what that salary range is. And if you stick to somewhere in that range, that would probably be considered reasonable.
All right, so I see a couple of questions around sort of location of business sort of versus the location where you form the entity. Those are very good questions. So let's say you form an Illinois limited liability company. So that was one of the questions. And you're doing business in Illinois, that's perfectly fine. You're formed in Illinois. But let's say you open an office or start doing business in Indiana and Wisconsin as well. Every state has a test for what they call doing business in that state. And once you start doing business in another state, there's a separate filing you make. So let's take Wisconsin, for example. Let's say you had some restaurants here around Chicago, and then you opened some restaurants up in Milwaukee. So you would then become authorized to do business in Wisconsin. It's a form, another form at that same place we keep talking about, the Secretary of State website. And you're still an Illinois entity. You're not moving or moving out of Illinois. You're always going to be an Illinois entity unless you change that. But you're becoming authorized to do business as an Illinois entity in Wisconsin. And what that means is there would be a filing you'd make. You'd pay a fee to the Wisconsin Secretary of State. And then every year to maintain an entity, once you form an entity, you pay a fee to the Secretary of State in the state in which you form every year. It's usually called an annual report fee or something like that. And that allows you to maintain the entity in good standing. So in our example, in Illinois, you'd pay an annual report fee to the Illinois Secretary of State each year. When you become authorized to do business in a different state, you'd also pay an annual fee to that state in order to remain in good standing in that state. So it's always a fine line. No one rings a bell and tells you when you're doing business in a different state. You think about if you're an internet business, right? You may be, your products might be for sale in all 50 states, but that in and of itself doesn't mean you need to become authorized to do business in all 50 states. So it's a test, and you need to sort of look at the test in the state in which you're considering, but that's the filing that you would make. The related question to that I see below is, do I have to be a resident of that state to file an organization in that state? And it's a good question. The answer to that is no. So if you're a resident of Illinois, let's go with Delaware, for example. We talked about Delaware before as being a popular state for certain types of entities. You might live in Illinois. Maybe you have a co-founder. They live in Illinois, but you decide you want to form a Delaware C corporation. Perfectly fine. You can file. You don't need to be a resident of Delaware to become a Delaware C corporation. The one caveat is that one of the requirements when you form an entity in any state is you need to designate what they call a registered agent. The registered agent is nothing more than a person or a company who can receive notices from the state. If the state ever needed to reach you, you being the entity, they need to know who to talk to. And so they talk to the registered agent. That's who the communications go to. The registered agent has to be a resident of the state in which you form. So if you formed an Illinois entity, you as the founder could serve as your own registered agent, right? Easy. Just list yourself as the registered agent and the state will send notices to you. But if you form a Delaware entity, you can't be the registered agent because you're not a resident of Delaware. But there are companies that will serve in that capacity, lots of companies. You can find them online. CT Corporation, Harvard Business Services, there's many of them. For an annual fee, they will serve as your registered agent, and you would list them in the Articles of Incorporation or Articles of Organization or Certificate of Formation, whatever document you're filing. So when you form in a different state, there's that requirement of designating a registered agent and paying them some money each year, which you may not have if you form in the state where you reside. But the answer to the question is absolutely yes, you can form in a different state.
Okay, I'm going to answer a really easy question. Someone asks, does your organization offer startup coaching? If so, can you post the information? So we don't offer startup coaching, but we do provide legal services to our clients. And so if anyone's interested in applying to be a client, we do a lot of legal work and we don't charge for our services. It's a class at Northwestern. So law students do the underlying work and it's supervised by faculty members. Did you guys hear my dog bark, Darren? She's very loud right now. So anyway, it's in September is the next time we'll be taking on new clients. So of course, if there's a project you have that's a rush, we wouldn't be able to help. But if there's something that you think you might need help with in a couple of months, sadly, September's not, the summer flies by. I hate to say it. In August, we will be reviewing applications. So that is an option. And I'm going to put the link to our application, our online application. It's really short and easy to complete. I am going to put that in the chat.
And while Esther's putting that in the chat, and we hope to see lots of you apply. We love working with businesses that we meet through these presentations, through this program. So definitely, if you apply, note that this is how you met us. We can only take so many each semester, just because we have limited number of folks to work with everybody, but We love to work with companies that come in this way. So definitely let us know, and we'll do our best to accept you into the DPELC. I see two questions that I'm going to answer that are sort of related here. My answers will be frustrating and annoying because I don't have a great answer to either one of them. One was, when should you get a lawyer when you have a startup business? And the other is, when should I get insurance when I have a startup business? Two very good questions and very tricky questions. On the lawyer front, it's always a balance, right? So when you're starting a company, most founders don't have unlimited funds, right? If you had unlimited funds, of course, you'd hire a lawyer immediately and you wouldn't worry about it. But most founders have lots of expenses they need to pay and limited dollars, right? So can't spend all our money on legal. It's generally a good idea, if you can, to establish a relationship with an attorney early on. That doesn't cost anything. You can reach out to an attorney that does the kind of work which is sort of relevant to what your business does, and an early stage startup attorney, an entrepreneurial type attorney. So you can establish that relationship without paying anything. And it's a good idea sort of right up front, just so you have them ready to go. There are certain things you might be able to do on your own. We're not talking about trademarks today, but that's something sometimes founders will try to do on their own, or they might work with a lawyer. Forming an entity like we're talking about, there's lots of online resources to help you through it. If you're forming an entity and you're the only owner, you're not going to have co-founders, you might be able to form a pretty simple entity and do a lot of it yourself online. Maybe you have a lawyer you've established a relationship with and you kind of have them available for questions, but you're kind of taking the lead. If you were forming a business with two other co-founders, figuring out who's going to run the business, how decisions are going to be made, generally a good idea to bring a lawyer in if you can for at least a little bit of time to help you think through some of the questions you might not even know to ask. So earlier better with a lawyer, but within reason. Within reason, you can sort of manage the process to manage that spend. On the insurance question, it's a similar answer. Again, if dollars didn't matter, you'd buy lots of insurance up front. Why not? Why not completely protect yourself against anything that could happen with insurance policies? And there's more insurance available than ever these days. The policies have gotten very specific. Of course, dollars do matter for most founders. So lots of the businesses we work with will sort of purchase a general liability policy early on, maybe what they call an errors and omissions policy early on, sort of some of the big ticket broad policies. Some buy more than that. It depends on their specific business. Again, half the battle's thinking through insurance. You can talk to like a small business insurance broker, describe your business to them. And if they're good, they should be able to give you sort of a menu of relevant insurance policies. You can price them out and then decide what makes sense for you. And sometimes you buy the basic up front, and as soon as dollars are available, maybe you purchase another policy that seemed like it would be helpful to your business. But just doing your due diligence, talking to folks, a lawyer or an insurance broker up front, will help you determine what the right time is to do those things.
Sorry, I was getting off mute. So I'm taking all the not-for-profit questions, I guess, because I talked about not-for-profits. Imagine that. Someone asks if you can file those online in Illinois. Yes, you can. And it's $50. It's the least expensive of the options. And then you can also apply online with the IRS to apply for tax exempt status. There's different forms for that. It's called the 1023. But if you plan to be a smaller organization, a smaller budget with less assets, there's something called the 1023 EZ, which, like its name, is much easier than the full 1023 application. The other thing I wanted to mention for anyone who is thinking about a not-for-profit in Illinois or has formed one, there's actually this terrific guide on the Illinois Secretary of State website, so ilsos.gov. It's called a guide for organizing not-for-profit corporations. And I don't know how people usually feel about, reading long manuals before they do something. This one's actually super helpful. It's well written, it's clear, it gives a ton of information. I used it a lot when I was first helping clients in the space to go back. It answered a lot of my questions. So I would say it's a really good resource if that's something that you're thinking about. I would suggest just Googling that, and you can find the manual, and it will probably be pretty helpful.
So I will take, I know we only have a minute or so or a couple minutes left, but we'll answer until we can answer no more, until we're out of time. So there's a question around IP protection, and then there was sort of a follow-up question around IP protection. So we're not going to get too deeply, obviously, into intellectual property protection here today, because it's sort of a whole topic by itself. But it's a very good question. It's a very important thing to think about early on, how a company protects its IP, whether it's through non-disclosure agreements, through filings that you may make with governmental entities. But the follow-up question, I did want to talk a little more about, do you provide services to help with IP protection? You being the Donald Pritzker Entrepreneurship Law Center, presumably. And the answer is yes, certain types of IP protection. So, and maybe this is a chance to talk a little bit about some of the types of things that we do in the DPLC. One of the things we do is what we've just been talking about. We help with forming entities. So if the fall time frame was when you think it would be reasonable for you to form an entity, we can often help with that, depending on what type of entity it is and what you're looking to do. As it relates to intellectual property protection, we do a lot of trademark work for our clients. So we'll help clients, we'll search trademarks to see if we can find other conflicts which might be out there, issues that a client might have in using a particular name or brand or logo. And then we'll help, if you wanted, we help to file for federal trademark protection with the United States Patent and Trademark Office. And again, we won't go through the details there, but that's another thing we do. Yet another thing we do is if you had certain contracts that your business needed, if you were needed a customer contract for the customers you were going to be bringing in, or maybe you have an independent contractor that you're going to engage to perform certain services for your business, we can help draft that contract. So those types of things, helping to form an entity, drafting certain types of contracts, and helping to protect trademarks, those three things, we do a lot of that for our clients in the DPELC. So to answer that question, yes, we can help with certain types of intellectual property protection.
So I'm going to wrap up just by saying one thing that I posted, it's actually all the same link, but if you go to our website, and I posted the link to the DPLC website, under client information, there's a link to our application. Again, it's super easy to fill out and quick. There's also, if you scroll to the bottom of the page, there's a workshop that Darren and I did a couple of years ago now at 1871, which you may have heard of as a incubator space for tech startups mostly. We did a workshop on trademarks, and they recorded it. And so if that's something that you're thinking about or want some more information on, I think it's like a 20 minutes, probably something similar to this, but on trademarks that's recorded. So please feel free to view that if that would be helpful to you. And then someone else also asked earlier, is this being recorded? Yes. And I think they're posting the recording of this on a YouTube video, and I'm sure you can get more information on that. I want to thank all of you for your excellent questions. This has been fabulous questions, a really engaged audience. We so appreciate your taking the time to spend with us today to talk about legal issues, which for us, it's our favorite thing to talk about. And so we appreciate you indulging us and letting us have this time with you to share some of our experiences and things that we've seen with our clients. So thank you. I will pass it over to Darren to say goodbye and hope to see all of you soon.
I have nothing really further to say other than to echo Esther's thank you. It's always fun when we get lots of questions, the engagement and the back and forth, we really enjoy. So hopefully this was somewhat helpful, at least to you all, and we hope to see you all out and about at future presentations or as clients, and thank you for your time.
Great. Thank you, Esther and Darren. Appreciate your time always. I did put the YouTube page in the chat, and Esther, I put your link that you were talking about in the chat to everyone as well.
Oh, thank you.
Yes, no problem. So again, thank you, Esther and Darren. Thank you, everyone, for attending. Hope everyone has a safe and fun night. Have a great night, guys.
Bye.